Well, it's a banner day for the Pac-2, being Washington State and Oregon State, as they get a huge win in court that goes a long way towards securing their future. They now have control of the governing board of the Pac-12 conference, not the outgoing 10. Now, there may still be a lot of messiness to come, and we're going to break it all down here in this video. Welcome into the channel. I am John Kurtz. Here on this channel, we talk college football, conference realignment, and college hoops, all from a Big 12 angle, and we do it all week, every week. So please consider subscribing if you have not, and make sure you catch the live shows on Wednesdays and Sundays. They are a blast. If you could like the video, comment underneath the video, agree, disagree, love me, hate me, all of that stuff really helps, and you can support the channel on Venmo at John-Kurtz-4. Okay. We have a lot to break down here. Jon Wilner himself, who I'm about to read this article from, who covers the Pac-12 unlike anybody else for the Pac-12 hotline with the San Jose Mercury News, he even admitted he was a bit surprised by the fact that this ruling came down the way that it did. We had an initial ruling that went in favor of Washington State and Oregon State in all of this, but then secondary ruling that put a halt to that. It was being pushed to the Supreme Court of the state of Washington, and now they have handed down their ruling. And here is the article from Jon Wilner, who says, left behind in the realignment game and scrambling to secure their futures, Washington State and Oregon State won a momentous victory in court on Friday that gives the Pac-12's two remaining schools control of the conference's governing board. The Washington Supreme Court denied a request by the 10 outgoing schools to review a lower court's preliminary injunction that has established WSU and OSU as the only members of the board. So remember, the concern for Washington State and Oregon State originally was that if the 10 outgoing schools were still a part of the board, they could outvote them on things. They could control some of the finances here, control some of the money, when obviously Oregon State and Washington State are in a very precarious financial situation themselves based on everybody else leaving and the conference, in essence, breaking up. Quote, here's a statement from both the university presidents at Washington State and Oregon State. Quote, "We are pleased with the Washington State Supreme Court decision today. We look forward to continuing our work of charting a path forward for the conference that's in the best interest of our student athletes and wider university communities." The Supreme Court's decision lifted a stay on the injunction that had been in place for weeks, thereby clearing the way for the Cougars and Beavers to control the distribution of assets and revenue and determine a plan to handle liabilities. Now, I'm going to get to this later on, but Jon Wilner actually says, a lot of the attention here is on, okay, they theoretically get control of the war chest, right? The quote-unquote war chest of money. But he is saying one of the bigger issues is going to be managing liabilities. Now that they have control, they can determine the best way to manage. There's the Comcast lawsuit, stuff with the Holiday Bowl. There is also the House case that's going on in the NCAA right now, where the Pac-12 is a defendant, and they could be on the hook for millions and millions of dollars there, as would almost everybody in college football. So there's a lot that is going to have to be managed here in terms of liabilities, money that would be going out from the conference. Wilner says the court ordered that both motions for discretionary review are denied. Because the motions for discretionary review are denied, it's not necessary to consider whether to retain or transfer the motions pursuant to RAP 4.2. And here he goes into something that's really interesting. The outbound schools did not issue a statement following the ruling, a possible indication that they were taken by surprise. So this is the group of 10 that is departing the conference did not issue a statement. Now, the other steps along the way, they've been quick with a statement. We've seen lots of statement battles between both sides. They did not have one here in the immediate aftermath, which Wilner is saying likely indicates that they were taken by surprise. What happens next is not immediately clear. The departing 10 could agree to a settlement after months of failed mediation. Perhaps one of the schools outside of Washington will pursue legal action in its own jurisdiction. During a court hearing in November, the defense raised the issue of dissolving the conference. Might that be a desperation move to regain leverage? So yeah, a couple options here. Obviously, this was legal action all taking place in the state of Washington. Does somebody else try to challenge it in their own state? Honestly, we're getting way over my head in terms of how that works, what that would mean. I am not a legal guy. I'm a college athletics guy. But the interesting part to me here is dissolving the conference potentially being used as leverage, because, look, the two remaining schools would like to hold on to the Pac-12 branding as long as they can to see if that's something they may want to use long-term in the future. They're going to operate as basically a two-team conference at least next year. They have a 2-year grace period to do that, but eventually, would they want to bring in schools from the Mountain West under that Pac-12 banner? And dissolving the conference potentially could threaten that. Is that something that would be leverage enough to get everybody back to the negotiating table? I think these are all things that will have to be monitored here now and see where the 10 are going to go, because their silence is a little bit ominous in that. I mean, I can understand saying, hey, they were caught off guard by this and didn't have a statement ready to go, but you also think, man, they're probably just back plotting and scheming. Like, what's the next move? What's the next best thing that we can do if they're not going to say anything right now? Wilner continues to say there is more to play out for sure as the process enters its 4th month. The lawsuit began in September following the collapse of the conference and gained some clarity in November when a Whitman County Superior Court judge ruled in favor of the Cougars and Beavers. Gary Leiby, whose courtroom is an hour's drive from the Washington State campus, granted a preliminary injunction that declared the 2 schools the sole members of the board. But 2 weeks later, the Washington Supreme Court Commissioner in Olympia stayed the injunction. That decision meant the board could only conduct business if all 12 schools agreed. So it gave the 10 schools basically their rights back on the board. So a couple things that have happened recently that Wilner points out. Several weeks ago, the board unanimously allowed Washington State and Oregon State to enter into a scheduling partnership with the Mountain West for 2024. The money used to secure the agreement will come from the Pac-12 revenue generated after the defendants leave the conference. And last week, the Beavers and Cougars prevented the conference from making its traditional mid-year revenue distribution to the campuses. That distribution would have amounted to $5 million per school, but Oregon State and Washington State rejected the move based on financial concerns. Specifically, the 2 schools wanted full agreement on a plan to handle the future liabilities expected from the court cases against the Pac-12 and the NCAA. Washington State and Oregon State are bound by the framework of the preliminary injunction to include the 10 other schools in board meetings, although only the Cougars and Beavers will have voting rights. All right, so the withholding money, we've talked about that. That was basically them saying, look, until we have a full plan in place as to how we are going to handle financially liabilities that are coming down the road here, we're not going to give this like mid-year payout. That is a part of the money that's coming in. They can't just hoard it all for themselves. That is definitely a piece of this I'm going to get to a little bit from CBS Sports that outlines this in a different piece. They can't just take that entire war chest of money and hoard it for themselves because of how these legal proceedings have gone. But they can, for right now, say, hey, we'll get it to you later. We need a plan. We need to make sure we have all our ducks in a row as to how we are going to do this so that we don't just get an avalanche of liabilities swallowing us up, and us being the 2 schools there, Washington State and Oregon State. From CBS Sports, while Oregon State and Washington State have controlling interest in the Pac-12, the pairing is still required to act in the fiduciary interest of the entire group, so the financial interest of the entire group. The schools do not have the ability to withhold money that is rightfully owed to the departing 10 members. Oregon State and Washington State opted to withhold 15% of the conference revenue distributed in December. The decision incensed the departing members and was expected to be used as proof that Oregon State and Washington State should not have controlling interest of the conference. So where Oregon State and Washington State were saying like, hey, chill out, we got to make sure that we've got our asses covered here. The 10 departing schools said, like, this is proof that you guys can't handle this. You are going to hoard the money, and therefore we should have some rights here back on this board. But the Supreme Court in the state of Washington did not agree. Now, that is one way. That is the very, John Wilner, big time journalist. That is a very journalistic way of outlining everything. Here we're going to get into a little bit more of the narrative piece of this, because John Canzano had a little tease to his article, and I thought this laid it down more in terms of like what could be more palatable and easier to digest for everybody. He says the order was a legal beatdown. The Supreme Court of Washington denied both motions for discretionary review on Friday and granted control of the Pac-12 conference to Washington State and Oregon State. The Cougars and Beavers won by knockout. The 10 departing schools fell silent in the wake of the court's decision. No concession speech, no written statements, no vow to appeal. Were they in shock, licking their wounds, plotting, or counting the ways in which they're now at the mercy of the 2 schools they punched in the neck last August? So that's a much stronger way to come out and say what happened here from John Canzano. Now, some extra context from John Wilner. This was on Twitter. He had a tweet thread about this, but he says, at one point in early November, the 2 sides were close to a mediated settlement, but per multiple sources, the defendants, the 10, not just Washington, opted against that. And he wonder if they are regretting that now. So they almost had a settlement on this instead of going through all this court battle that's played out over the last 4 months. I guess this would have been, about a month ago. They could have saved themselves a month. But instead, they decided not to do that. Wilner does say, though, but Having spent 3 months in the weeds of this, I would be very surprised if the two schools tell the 10 to pound sand. That doesn't do anyone any good and just clogs up the path forward. And a part of that would be, like we said, legally, they are still required to act in the fiduciary interest of the conference. If they were to just give the middle finger to everybody, you're going to get the law back involved. That complicates it even more. It's going to make it take longer. And what Washington State and Oregon State really need more than anything is just clarity on what it is that they're going to do and how to proceed forward. Wilner says the biggest issue is determining a reasonable plan to deal with the House damages. Now, when he says the House damages, that means this case, the House case against the NCAA. He says as a named defendant, the Pac-12 could be on the hook for many hundreds of millions of dollars. Two schools cannot carry that burden. So the House case, that's former Arizona State swimmer Grant House, who in 2020 brought a lawsuit against the NCAA for NIL. There are a couple other athletes also mentioned here, but the plaintiff's attorneys claim athletes who were restricted from cashing in on their fame before an NIL ban was lifted in 2021 are owed damages for what they would have been able to make. So anybody who did not participate in the NIL era of college athletics is saying, hey, we are owed money in a class action lawsuit because we didn't have the opportunity to get the money that the athletes are getting now. Wilner says, admittedly, he is surprised by the decision, thought the court would review, and given that the order is now 75 minutes old, of course, this was at the time, and the defendants haven't issued a statement, I'm guessing they were surprised too. So a ton to chew on there. In particular, it's part about the House lawsuit. I mean, that is a very significant thing that this league is going to have to worry about. But you guys know, if you've been watching this channel for a long time, I'm very pro Oregon State and Washington State. I am very pro them getting control of the league. So I was definitely happy to see this decision come down. Please consider subscribing if you have not to this channel. Live shows Wednesdays and Sundays. Make sure to check them out. They are a blast. If you could like the video on the way out the door, I would much appreciate that. College football, college basketball, conference realignment all the time here on this channel. I appreciate all of you guys. Take care, and I will talk to you soon.